So here to talk to us about the verdict in the disgraced Hollywood producers trial and what we can expect next is legal analyst and KUSI contributor Vikas Bajaj. Vic, thanks for joining us.
Thank you. My pleasure.
Okay, what were your thoughts when you heard this verdict come down?
Well, first, I think chronologically it was a bit of a roller coaster. If you follow the case closely, as my household members have and my office has, you said on Saturday the jury was hopelessly deadlocked. The jury was unable to come forward with the case and a conviction for any one of the charges. And then the judge gave what we call in the legal industry the Allen charge, and that's because of a case, People versus Allen, a long time ago, which said a judge could really encourage the jury to deliberate more if they were unable at that particular time to reach a consensus. So that's exactly what happened on Saturday. As a defense attorney, you hate that admonition because you would much rather have the opportunity to have a hung jury and then a potential of a retrial. When jurors are given this Allen charge, they go back there and they say, well, you know what, our duty is to come up with a decision, so let's do that. And there's additional pressure and additional deliberation. So you can see that being an appellate ground that his defense team will explore, as well as the venue issue, which is one where he was just too well known and jurors had every idea of what was going on with his case. But as far as globally, once we're done looking at it chronologically, there are no surprises here. It is very fortunate that prosecutors and prosecution teams around the nation now have a bit more leeway as to which types of evidence that they can actually present. And as we know now, some of these allegations are quite aged, markedly aged, and statutes of limitations on sexual assaults have been rolled back throughout the nation, and we've seen that here in California as well.
Now, he was found not guilty on the two most serious charges, the ones that we're talking about, predatory sexual assault. That would show a pattern. But now, I was talking to you about this before our segment. More than 80 women have come forward saying that he did something to them, and not just inappropriate, but criminal. Why doesn't that establish a pattern? Why didn't they have more people come forward and testify against him?
What a wonderful question. In our world of law, in the court of law, both federal and state, if there's an allegation that can increase your punishment, and the allegation and enhancement you're referencing can increase it to a life term without a potential of release, whenever there's an enhancement or allegation that can in fact increase the punishment, it must be proven beyond a reasonable doubt, not a preponderance of the evidence, not more likely than not. So it may be that the court itself, the judge, as a gatekeeper, said some of the allegations just aren't corroborated, just aren't strong enough. And of course, the jury found some of those charges to be insufficient to bolster the pattern of conduct allegation that we have also in different jurisdictions, even in California.
Why don't you think that they called more of these, some 80 women? Would you have done that? Would you have called more people to come testify?
Well, I mean, as a defense attorney, I would bolster my client's credibility and call witnesses to talk about his truthfulness and honesty, of course, if he or she were to testify. On the prosecutorial side, you would like to have a list of 200 witnesses, if you could, and put the duty upon the judge and the defense attorney to argue, in other words, to siphon that down into maybe a couple of dozen. More witnesses, we should understand, is not necessarily more powerful for the prosecution. The strength of the witnesses is what really carries the day.
Okay, and people are saying this is a watershed moment for victims of sexual harassment in the workplace, and you say an appeal could be coming.
It can, yes, but one additional point, it not only is a wonderful thing for victim advocates and those who have suffered these atrocious harms, but it also has an ability to handicap someone who is trying to defend themselves, because the statute of limitations, now withered away, prevents a person from going back 20 years and finding crucial evidence to help their case.
All right, Vic, thanks so much for that perspective. We appreciate it.
My pleasure.